We're on the record. Good morning. Welcome to the Maryland Public Service Commission's continuing rulemaking in docket RM70 with respect to proposed regulations for supplier consolidated billing. This is our sixth day of rulemaking hearings and quite possibly the last day. I'll begin by taking any appearances of parties that did not previously make an appearance on the record. If so, please speak now. How we're going to go about today to make it as efficient as possible. The commissioners have a few proposed edits that they would like to share, relatively minor, and we'll do that through our senior advisor, Molly Knoll. We'll then turn to commission staff to walk through the 6 items that were contained in the memo that they filed on Monday, March 8th, in response to commissioners' questions. We'll then allow for any feedback from the petitioners and other parties to this case. And then we'll conclude the day with a vote on the package of proposed revised regulations. Any preliminary matters before we begin today by any of the parties? Hearing none, I'll turn this over to Senior Commissioner Advisor Molly Knoll.
Good morning, Mr. Chairman, Commissioners. Molly Knoll, Senior Commission Advisor. These are some minor wording edits that I just wanted to get out of the way before we go into the substantive materials. The first edit is to 20.53.05.07a. I'm going to share my screen so if people can follow along at home as we go through this. If you 07A, I apologize, the red lines apparently changed color again on me. I've deleted commission authorization and changed the wording to say licensing that authorizes the provision of supplier consolidated billing. This is to be parallel to what has been proposed in the licensing regulations. I have 9 edits. After each one, I'll give just a moment for anybody to object. But if I don't hear any objections, I'll move on to the next one. All right, the next edit is to 20.53.05.07D2. In this one, I have a D2B. I've added use the information to at the beginning of B in order to make it parallel to A and flow properly from the intro clause. Hearing no objection. The third edit is to 20.53.05.08D. The edit here is the addition of the word under. I'm going to highlight it for folks on the stream. Again, it simply makes the following clauses flow better from the intro. The next edit is slightly more substantive. It's to 20.53.05.12G. I've pulled this up on the screen. The original language, I'm highlighting the edit right here. The original language was at no less than 2-week intervals. My understanding of no less than 2 weeks was that it could be more than 2 weeks. And I believe the intent of the parties was that this reporting should happen every 2 weeks. So I've changed the language to simply say every 2 weeks. I'll give folks just a second to digest that in case I did not properly understand the intent of the parties. Okay, the next one is a bit further down. It's in 20.53.07.09B2 little b, Roman little 2. It is on page 37. I apologize, my screen has hidden the page numbers. I've added a statement that to the beginning of this clause. Again, in order to make it flow better from the intro statement.
Miss Knoll, can you give me the site again?
Absolutely. This is in 20.53.07.09 B2 little b little Roman 2. And it's on page 37 of the red lines that Ben filed.
Thank you.
Sorry, Mr. Baker filed.
Thank you.
The next edit is to 20.53.07.10F. In this section, the edit that I made was they were referencing to subsection E of this regulation. Because subsection E is referencing sections A and D, I took out the middle step and simply referenced directly to A and D.
Miss Knoll, I don't think that that's a problem, but the intent of F was if you were going to transmit the notice with the bill, that it would be prominently displayed. So that's why it was referring to E, but I don't think that your change there modifies the intent, because if the customer's getting it, we want it to be prominently provided.
Is there any opinion from the commissioners on whether it should remain E or move to A and D? So in that case, I will undo this edit and leave it the way the parties had it so that we're not disturbing what was filed. Two more, and then I'll turn this over to the more substantive matters. The next edit is to 20.53.08.03A. Mr. Baker, this is in one of the edits that you have in green. I deleted the word where because I believe that it's not necessary to make the later clauses flow from the intro.
We had debate on this earlier, or not, me and my lawyer, Ms. Garofalo did. So yeah, I think that's fine if you believe it's a list. All
right, and then the final edit that I have is 20.53.08.03B. I added at the time of enrollment in supplier consolidated billing because the term enrollment is used also to apply when a customer simply signs up with a supplier. So I wanted it clear that we were not encompassing more than enrollment in supplier consolidated billing. And with that, this will be our active red line as we go through the discussion today. I will take this down, Mr. Baker, and let you start, and then I'll put it back up if we need to do more edits.
Okay, thank you. We will make the same edits to the gas regulations.
Yes, I believe that these will be conforming edits to the gas regulations. Some of the numbers might be changing.
Okay, thanks.
Thank you. At this time, we'll turn it over to staff to go through their summary document that they provided us on Monday.
Good morning, Chairman and Commissioners. Benjamin Baker on behalf of staff. So yes, I will walk us through the 6 items, and if at any point there are questions, please let me know. My proposal is we'll go through all 6 items, and if there's any proposed changes to the COMARs after we go through the 6, as we go through the final approvals, we will make the edits. With your permission to continue, Mr. Chairman.
Thank you. I believe Ms. Knoll may have forgotten one of the 9 edits that she made. Ms. Knoll, do you want to jump in now before Mr. Baker begins?
Yes, I do. Thank you so much for checking my work, Mr. Chairman. The last edit we're going to go up a bit is in 20.53.07.09A2D. I'm going to do my scrolling and then share my screen. In this section, I simply removed this clause and moved it to the end so that it was just more clear that the disclosure has to happen if this second clause is met, and then the purpose is placed at the end of the sentence. And with that, I think we're ready to move forward. Thank you, Mr. Chairman.
Thank you. We'll now turn to the staff. Mr. Baker.
Thank you, Mr. Chairman. The first item I would like to discuss with the Commission is the definition of price to compare. As was flagged at our previous rulemaking session, the price to compare could be considered a term of art and that it should be defined within the regulations. Staff went and reviewed the order that directed electric companies to have the price, basically directs the price to compare information on the electric utilities bills and what manner it shall be displayed. And while doing that, staff also determined that we do not have a similar regulatory obligation for gas utilities. So when drafting the definition, staff drafted such that the price to compare information is at the discretion of the Commission, such that if at a later date the Commission wants to provide a price to compare requirement for gas, they may, but we don't have one today. And so therefore the proposed language of our definition is on page 2 of the summary that we filed on Monday. And so it means a rate or language that the Commission may require to be printed on a customer's bill to permit the customer to make meaningful comparisons between competitive supplier practices and the price for standard offer service or sales service provided by the customer's utility. And with that, staff is available for questions. All right. So we will make, so that definition has been inserted into our 2053 and 2059 COMAR, and anywhere where we use the language price to compare, we have renamed it supply price comparison information. The next issue I would like to discuss with the commissioners is the statutory definition of supplier consolidated billing. Staff reviewed the PUA and determined that there is no definition for supplier consolidated billing within the PUA. And so we do not have a conflict between our definition of that and the PUA. Staff, though, did provide a red line to our original proposal for supplier consolidated billing, such that the definition is consistent between the different COMAR chapters. We had originally just stated in the electric COMARs as electric supplier, and in the gas COMARs gas supplier. Now it is gas or electric. And in that proposed language is in our summary on page 3. And all right, with no questions, I will continue to the next item. The third item, and this is more substantive than the previous two we discussed, is the bill adjustment for supplier charges. So this section of COMAR deals with if a utility or supplier determines that a mistake was made on the bill and they wish to rebill the customer. This is supposed to be the COMAR that governs the process for the supplier. At the previous hearing, the commissioners, some commissioners there were two concerns raised. The first issue was legal in nature, and there was concerns that the proposed COMARs would result in staff or the commission litigating the supplier's contract with the customer, especially in scenarios where the customer's price had not been previously disclosed. This would be very problematic in a variable rate proceeding. The second issue that was raised, or I won't say issue, but comment that was raised by one of the commissioners was if it was appropriate to continue to basically have a prescribed solution in the proposed COMARs, because they viewed this idea of bill adjustments as a transfer of bill of basically a sharing information between the parties, and that the premise was that the bill adjustments would be driven by the utility and not the supplier. And so therefore, if there needed to be a solution, the utility could do all the math on their side and just send the prescribed adjustments to the supplier to do the billing. In response to the legal question, staff has proposed COMAR language that would make it clear that we are not getting in between a customer's contract and the supplier, and that the bill adjustment COMARs only, the supplier can only initiate a bill adjustment if the price had been previously disclosed to that customer, whether it was through the customer's contract or following the prescribed COMARs for variable rate products, so that if we ever did get into a dispute with a bill adjustment, the commission would be reviewing a dispute that has to do with billing and not with the contract. And that proposed COMAR is on page 4 of our summary. The issue that has to do with if it's appropriate to have a prescribed solution in COMAR for the suppliers to follow. Staff still thinks it is appropriate, and we have provided the COMAR that we think does it. And the reason we believe this is appropriate is because we believe that that there will be bill adjustments for things other than a utility bad meter read. They could misprint the bill. They could receive the information from the utility and inappropriately calculate their total charges. There could be various reasons why the supplier may need to initiate a bill adjustment. And so we think that it would be appropriate to keep some form of a prescribed solution in the COMARs for the suppliers to follow. Otherwise, we could end up in a situation where every time a supplier needs to make a bill adjustment, they could possibly be at the commission, or we could have to basically through our CAD process come up with a solution at a later date. That stated, staff has provided the commission 3 different solutions in Appendix B of our filing if you disagree with our assessment. The first solution would keep in place our proposed requirement that has to do with 35% of the bill adjustment. The second proposal is less prescriptive and simply requires a payment plan that is no less length than the term of the bill adjustment at the request of the customer. And then the final proposal would have no solution in place, and the supplier could only, but we would have a COMAR that would effectively that would permit the customer to file complaints with CAD, such that the customer did have an opportunity to seek recourse if they thought they were being treated unfairly. With that, staff is available for questions.
Thank you, Mr. Baker, for particularly for fleshing out the 3 various proposals in Appendix B. I know that Commissioner Herman and Linton initially raised some issues regarding this item, so I'll defer to them first. Unless they are satisfied. They may be.
I think my preference is probably the staff's first option, Mr. Chairman.
Thank you. And Commissioner Linton, are your concerns addressed by staff's explanation and proposal?
I think it does resolve some of the concerns that I had. I think I could live with it. Yeah, I think it would work. I think in reality, the option of filing a complaint is always there anyway, so you kind of get 2 for 1. So I think it would work.
And just to be clear, Mr. Baker, the staff's proposed option, which is option number 1, is the option that is currently reflected in the regulations that were filed on Monday?
Correct. So it effectively, what we discussed in our previous rulemaking, that's embodied. The one change is the proposed regulation language such that we only get involved if it's a dispute of the bill and not a dispute of the contract. And so it's the same discussion we had last time. So it has the 35% limit that we discussed at the previous hearing.
Thank you. Commissioners O'Donnell and Richard?
I think I'm good with the staff recommendation. Can you just help me understand how does your option keep CAD out of the process? I mean, we're not limiting a customer, are we, from going to CAD if they have a dispute? I just want to understand, because that seems like an appealing approach. I just want to understand how it is that option 1 keeps CAD out of a supplier dispute.
So it doesn't keep CAD out of anytime a customer, if a customer has a complaint and they can't get it resolved with the supplier, we want them to come to CAD. What we wanted was a solution in place such that the suppliers were not left unguided for how they approached a bill adjustment, and that if a customer felt that they were being untreated or being treated unfairly, that there wasn't a prescribed process for them to see and say, no, this is the process that we said that the supplier will have to follow. So basically you're giving the guidance now for how you want to see a bill adjustment happen. If we don't give guidance, if we give no guidance, which is effectively option 3, the suppliers can issue their bill adjustments as they see fit, and there's not really a customer protection in place for that adjustment, which is fine. That would be our choice. And so staff's choices, yeah.
Okay, very good. I just want to make sure that we weren't eliminating customers' option of going to the consumer affairs division by not specifically spelling it out like the other 2 options. But your answer has satisfied my concern. Thank you.
Thank you.
And I think I'm good with this. I seem to recall that this wasn't there wasn't consensus on this particular point. Remind me, Mr. Baker.
Between us and the petitioners.
Yes.
Yes. So the petitioners had concerns with our 35% limit approach, and they wanted it to be less prescriptive. It was not that there shouldn't be a solution, but that it should be less prescriptive. And I believe they were looking for more the request. They were looking more for just providing a payment arrangement if the customer needed one.
Yeah, I thought so. Okay, I think I'm good with this. So thank you, Mr. Chairman.
I also support option 1, staff's recommended approach. So you have 5 votes, Mr. Baker.
Thank you.
The petitioners and the suppliers are interestingly quiet today. I see them all. Well, I don't see them, but I know they're out there. So speak up if there are issues contrary to your interests. But Mr. Baker, in not hearing anything, let's keep moving to item 4.
Okay. I envision we will hear from them on this one. The licensing condition certification COMAR. At the previous hearing, staff was we had a certification that was broad in nature, and the goal of this certification is basically to say if there are requirements for billing sorry, my apologies, my computer just cut out on me. This was a licensing certification where the supplier says we will follow all regulatory requirements required of a utility or a supplier that bills for charges. Staff was asked to basically reword this if we were going to keep it because it was viewed as too broad. And so staff has attempted to make this adjustment with our proposed language at the end of page 5. And Ms. Garofalo, if I've missed anything, please jump in.
No, good job. I think there was a legal question, but we do think the commission can do this. And the idea here is really you have an applicant, you want to make sure that they're going to try and do everything. We, as staff, believe that there are going to be some things that will come up that are not actually currently handled. We can't really specify them. It's similar to the current application, which requires certification that the applicant will comply with all environmental laws. We don't necessarily enforce those or know what they are. We want a similar thing like this, but this is more about billing in this particular case.
Mr. Baker, is there a reason we can't share this so that everybody's looking at the same exact language?
No, I would certainly welcome that. My apologies that it's not on the screen. Mr. Green, I know that you have some concerns with this proposal.
Sure. Good morning, Commissioners, Mr. Chairman. Look, this is not a hill that we're going to die on, but it seems redundant. This is in section E1. What's not on your screen is E2, where the applicant already has to certify that they will comply with all applicable statutes and regulatory requirements and maintain the following functions, and included is billing. So what we couldn't figure out is what are we trying to capture in this new language that's not already included in the next section of the same COMAR. So that, again, maybe it's belt and suspenders, but we just felt like it was redundant and we couldn't seem to figure out, is one intended to cover something that the other is not? So, again, we don't have strong objections to it, but we just wanted to point that out.
Mr. Baker, I don't hear any objections to staff's proposed language on certification.
Okay, then I will continue. Thank you, Mr. Chairman. The next COMAR, or the next section, I'm going to let Ms. Garofalo, as it's all legal in nature, so this should really be covered by her.
Well, so at the last rulemaking, there was some concern about the Commission's statutory authority to dictate call center metrics. Staff does believe that the Commission has that statutory authority under 7511, particularly B, and we have included this because we think the call center is going to be the customer facing, the face that the customer sees when there is a problem of any sort, or just a question. This might include the not only billing, but how much should I pay? How can I change my method of payment? There are all sorts of issues that need to be handled by someone. What we know now is they won't be handled by the utility. So we need an entity to step in there. It's our understanding that it will be the SCB supplier or a third party that the SCB supplier hires. And we just wanted to make sure that the customer could count on getting the same level of service from the SCB suppliers as they get from the utility, or within the ballpark anyway. And I'm not sure if I said that, but it's written here that 7507E gives the Commission broad authority to do this kind of thing.
Thank you for that legal analysis, Ms. Garofalo, and the write-up as well. Seeing no questions.
Your Honor, if I may, just for the record, my clients, and that's obviously all I can speak on behalf of, we are okay with the call metrics that are in the proposed COMARs, but we take no position on the legality of having suppliers conform with these types of regulations. But for purposes of pushing this through, getting it through the working group, and getting it approved, we are okay with these metrics.
Okay, Mr. Baker, the next item.
Mr. Chairman,
Commissioner.
this was my question, and I still have, I understand where you're coming from, Ms. Garofalo, and I appreciate your pulling that together. I still have questions as to whether or not competitive is supposed to be competitive, and I don't think collecting metrics is necessarily to address abusive practices. I mean, it might be if somebody wasn't answering the phone and then you could impose it because they were doing abusive practices, but I'm not going to oppose this language, but I do have some questions remaining. So, but I appreciate the legal analysis, and with that, I'm prepared to just move on, Mr. Chairman.
Thank you. We'll move on to item number 6.
All right. Thank you, Mr. Chairman. So the last item here deals with, so at the hearing, Potomac Edison at the very end raised a concern with the proposed COMARs related to eligibility and as they related to energy assistance customers, but they needed time to digest their concerns. And so after the hearing, Potomac Edison explained to staff what their concern was, and it was related to customers within the Utility Service Protection Program, so USPP. The way that the COMAR was originally worded, and Ms. Knoll, if you don't mind scrolling down to the next page, so everything except for what's in bold was included. What was the intent was basically of the commissioners ruling at a previous hearing was that energy assistance customers should not be participating in SCB until we complete a phase 2 to ensure that they are properly treated within the program. And so in our previous filing with the commissioners in February, we included an appendix that basically listed all the different criteria that could, and there's appendix A, but all the different criteria that that would qualify a customer as energy assistance. And one of those was if you were enrolled in the Utility Service Protection Program. The concern raised by Potomac Edison is that under our definition here, there could be customers without the bold part. There could be customers in the Utility Service Protection Program that don't meet the criteria that a customer has applied for or is receiving funds from the Office of Home Energy Programs. Staff is concerned then that those customers who have no part in the energy assistance programs and don't have an arrearage and don't have a payment arrangement, who then choose to be on who want to be on SCB would then be precluded from being on SCB. So that is our concern with including this language, that we would keep a customer from being in the SCB programs just simply based off of them being my apologies, I got kicked out. The one concern, so therefore staff does not think the language is necessary, because if the customer has energy assistance or is in USPP because they got energy assistance, then they're covered by this COMAR. But if the commission does want to exclude all customers on the USPP program, this proposed language here would do that. And if Mr. Trout or others would like to weigh in, please do so. Thank you.
Good morning, Mr. Chairman, Commissioners. And I'm sorry that we're fighting in front of you about this issue, because I don't know that we're actually fighting. I think we're just talking past each other, and neither of us is quite understanding what the other's concern is. Our issue is that there is a small but real population of customers who apply for and receive receive energy assistance, but who use up, we're an electric utility, and they use up their funds on the gas side. So by the time they get to us, there's no money to use, but we're still told that they qualified for MEP and assistance, and that they therefore qualified for USPP, and we should enroll them, and we do. And we are just concerned that this phrasing without the language that we seek to add would somehow cause those customers to fall into fall between the stools. So as I understand staff's argument is that those customers are already covered because they're receiving MEP, they're just not receiving it from us, or they're not receiving it through us. And our argument is that we see them only as, on our system, USPP customers, but they're still qualified. They've still already qualified for energy assistance. That's how they became USPP customers on our system. So staff intends the customers to be covered. We intend the customers to be covered. I think we are saying exactly the same thing about exactly the same people, but staff says we don't need these words, and we feel that to make sure nobody falls through the cracks, we do need these words. And I think that's the whole dispute. And I would rather have the language in there and err on the side of making sure that the customers get the protections that they would need. And staff is concerned that this will somehow exclude people who would not from SCB, which would otherwise be excluded. And that's certainly a legitimate concern. I just don't think it will actually happen in the real world. So that's why we're in front of you about this language. Now, having said all of that, since I don't work directly with customers except in extreme situations, if anybody has any questions about how this actually works, we have our subject matter experts standing by ready to talk more about this. I've kind of explained everything that I know, but I really do. I think we and staff in some ways are saying the same thing, but we're doing it with different words. And it's not that either of us are wrong. It's just because we operate our system, and we know that if somebody's in and they're not getting assistance through us, they've gotten it through their gas company, and they're only on our system as USPP, we want them treated the same as the rest of the energy assistance customers, because that's how we treat them. Anyway, that's the story in a nutshell. And now Mr. Rockwell is going to explain how I've screwed it up.
No. I'm gonna. What I was going to say, and what I will say is, I think Mr. Trout has explained this correctly, and we think the or enrolled in the Utility Service Protection Program is really just extra, and does not need to be there, and might be confusing.
All right, thank you. That was a pretty big nut to put in the nutshell here. Mr. Trout, you view this as more of a belts and suspenders inclusion to accommodate the, like you said, very small percentage of the population on energy assistance that may actually participate in USPP. Is that right?
Yeah, I think that's a fair characterization. Having it in there does no harm, and it makes sure that, or it reduces the chance that somehow we'll stumble. We, the utilities, will stumble.
Ms. Garofalo, can you respond to that? It doesn't seem like additional specificity does any harm, but maybe that's your argument that it does.
Well, it doesn't do any true harm, except to the, perhaps to the people in Annapolis and perhaps to me, but I would have to admit it doesn't do any true harm.
Thank you, Ms. Garofalo. That admission may be fatal to your argument, but let me see if any of the commissioners have concerns with Potomac Edison's proposal.
Mr. Chairman?
Commissioner Linton.
Thank you. Good afternoon. I just have one question for, I guess for Mr. Trout. Do you have any USPP customers who are not receiving LIHEAP money and who are also not receiving EUSP money?
I'm going to have to ask Ms. Dye to answer that question. You have pushed beyond the envelope of my knowledge. Shelley, are you able to respond to the commissioner?
Sure, absolutely. Thank you for giving me the opportunity to speak. We do have some customers that are on the USPP program only. Typically, we do get those from the agencies when the customer is electing their MEAP grant to be used towards their gas utility, but they still want the winter protection. So we'll get notification from the agency to enroll those customers into the USPP program only. And to address your question, Commissioner, sometimes it is rare that we would get those only because most people do elect EUSP. We do have those few where they don't want EUSP because of budget billing. So they will enroll into USPP with budget billing. So there are those rare circumstances. And also, if the customer chooses to use the waiver to apply their MEAP grants lump sum in another situation, we leave their USPP intact so they still get that winter protection. So there is an opportunity that they could have no money on their account and still be on the USPP program.
Okay, well, thank you. That helps clarify for me. Mr. Chairman, for what it's worth, I would not be opposed to the language that Potomac Edison has proposed.
Any other opposition to Potomac Edison's addition here?
Mr. Chairman, I don't think I have opposition. I just was trying to understand when we got into this discussion of harm. It says staff does not believe it's appropriate to deny the customer SCB service. So is there a circumstance if someone is on USPP service, but they don't have an arrearage program, they don't have an arrearage, or a payment program? I'm not trying to understand what the nature of the relationship then of that customer with the USPP program, and how if they're not taking advantage of any of the services of that program, how then do they get off if they were to want to choose an SCB supplier? Maybe Mr. Baker, you could help me understand this, or Ms. Garofalo.
Right. So let me make sure I have your question correct. So why is there a situation where a customer could be on USPP, they don't have energy assistance, they don't meet any of our other eligibility requirements, but because they're on USPP, they're being denied service to be an SCB? And then your second question is what could the customer do to get around that?
Essentially, I guess I'm trying to get at what the staff raised as I think was the element of the harm, and that is a customer would be denied the opportunity to go to an SCB supplier. Right.
And so, yeah, so originally when staff was opposed to this language, our understanding was there could be some USPP customers who really were not energy assistance customers, but were still USPP customers. So if that's not the case, then that would, I guess, still make them energy assistance. But in terms of your second question, I think we don't have a process yet, or I would say, yeah, we just don't have a process for the customer to get around this. One of the things that staff kicked around internally, never discussed with the work group, was maybe there's a way that the customer, if they said they got their notice that said, I can't be a part of SCB, could that customer, because I'm an energy assistance customer, well, could that customer call up the utility and say, I would still like you to process my enrollment, and then there would have to obviously be exceptions to how they're treated. But that's one of the reasons we went to a phase 2, because there are complications with that. So there's not a process today for that customer to get around this. And I guess if you wanted us to develop one, if the customer asked for a request, we could talk about it as a work group and come back to you. But this was one of the key reasons why the parties wanted a phase 2, was because there was complications with that customer preserving their energy assistance funds and how it's treated and the customer protections associated with it if they were to go to SCB, and how we were going to, I guess, maintain that. So we don't have a solution today.
Okay, I have no objection to the language, and I agree. This sounds like it's going to affect a very, very small population, and it sounds like it's a very appropriate thing to talk about in phase 2. So thank you, Mr. Chairman.
Thank you, Ms. Knoll. I think at time, can you just remove the screen so we could see everybody's faces and see if other commissioners have any questions? Thank you. Okay.
Mr. Chairman?
Commissioner Linton.
Oh, thank you. Well, I was going to reference something on the screen. But since we were in a section that I had some concerns about that I expressed before, I thought I'd ask just a clarification question for myself, because I didn't think I did before. In section G3, the first part of the sentence references customers who have applied for assistance from the home energy assistance programs. It doesn't necessarily mean they've received it, but only that they've applied. And that fits because of the OR clause that's in there. If a customer has applied for energy assistance, they can be rejected from participating in SCB. It doesn't appear to rely on the outcome of the application. So are you able to help me understand how is that envisioned to work if a customer has only applied for assistance?
This would be a hold. So if the customer has applied to OHEP and OHEP has told the utilities sorry, I want to mute. There could be a 55-day hold put on their account, or if it's in the case of medical assistance, a 30-day hold put on the account. And so in either of those two situations, in the case of a hold, that's how that phrase was going to be implemented.
So in the event that, let me take the first part of your answer then. In the event that a customer's application is rejected by OHEP, so they don't receive any assistance, and they don't fall under either G1 or G2, they can participate in SCB once the hold is lifted.
Correct, and we don't have a process that would say the utility would go back and the utility would go back and notify them about that, and then process the transaction. I think what would have to happen is the customer would have to re-sign with the supplier at that point, at least how it's currently envisioned. So if we wanted a scenario where the customer, if we wanted a automatic situation, we would need to build the process to do it that way, but that wasn't how we built it. So it was going to be at time of enrollment. If you met one of these three criteria, your application for SCB would be rejected, and then at a later date you could reapply, but there wouldn't be a future triggering mechanism to bring in. At least that's not how it's been envisioned. We could go and do it differently, but that's how it's been built so far.
Okay, so I guess if you could, if I could take the second half of your answer regarding the medical hold, which is, from the utility perspective, it's a a different amount of time, but it's the same kind of hold on the account. You stated earlier that this was meant to cover those as well? So for
The holds, yeah, so the language has applied for, that is meant to cover the hold.
So
I don't think, give me 1 minute to pull up our February filing. I don't think we had any other criteria outside of that hold situation.
I'm talking about the medical certification hold. Is that the kind of hold you were referencing?
Yeah, so the 55-day hold and the 30-day medical certification hold. But the 30-day medical certification hold would have to be initiated by OHEP. Or it would have to be for energy assistance purposes. It couldn't be for, because I think there's other holds the utility can initiate today that are unrelated to energy assistance.
Right, and that's what I wanted to make sure that we weren't saying that if a customer had a medical issue and applied and sent a medical certification to the utility company, that would make them ineligible to participate in SCB. That's not what we're envisioning here, is it?
No, at least that's not how staff is envisioning this. Staff is envisioning this as a customer. And that's why we worded it as such. If you have energy assistance money, if you have a potential of receiving energy assistance money, or you have received energy assistance money, then we're going to consider you to be an energy assistance customer, and you will not be able to participate in the SCB program at that time.
Okay.
That's also how, at least this utility is contemplating it would work too, Commissioner. We understood the language in G3 to refer to the 55-day hold, and whether or not a customer applies for a med cert does not in and of itself have any impact on their ability to get the supplier consolidated billing. Now, if they apply for a med cert and they fall into G1 is going to disqualify them, but that's not because they applied for a med cert. It's because they have an arrearage more than 30 days old.
Right. That's.
So we understood the language that you pointed to in G3 as referring to the 55-day hold while we're waiting for the aid agencies to process an application for energy assistance.
Okay. All right. That was my question. Thank you very much, Mr. Baker and Mr. Trump. Thank you, Mr. Chairman.
Thank you. Any other comments? Okay, it appears that the consensus of the commission is to revise the regulation to explicitly state USPP as recommended by Potomac Edison. Mr. Baker, does that round things up for you?
I believe so. I guess I'll take a minute. Do the parties have any additional concerns with the edits that we have proposed at this time, or other issues that we have not addressed? All right, then that would conclude what I have, Mr. Chairman.
Thank you. It appears that at this point, if the parties have nothing else to propose or entertain before the commission is prepared to vote on this package, very comprehensive package of regulations. I'm going to call a relatively simple motion to adopt the proposed regulations in the 4 subtitles that we've been working in, the 2 gas subtitles and the 2 electric subtitles. As I call the vote, to the extent that the commissioners wish to elaborate or perhaps put some distance between the package and particular items, they may do so. So before I call the motion, any final items by commissioners or others?
Mr. Chairman, do we need to, before you do the approval, insert the USPP language into the COMAR, or since you've approved it after the hearing, that will just get inserted? Just a, I guess, process.
It's a process item. In the motion, I will remark that to the extent that there have been regulations as amended here today, which would include that USPP P item, it'll be included. Actually, sorry, right before the vote, I have one question for you, Mr. Baker, which I neglected to ask. And this is in the consumer protection regulations that are proposed, both gas and electric. So I'm talking about chapters 6 and 7. 6, I believe, is non-residential. 7 is residential, or maybe I got those two mixed up. I thought I spotted a discrepancy late last night where, with respect to non-residential customers, they have a minimum of 3 days notice before the supplier could cancel their contract. But with respect to residential, that's 5 days in both gas and electric. Can you just explain, was that difference between 3 days and 5 days intentional?
Yes, the three. So we lots of lively debate during the work group over this. We're basically what we're saying for non-residential customers is the supplier, before they can drop them for non-payment, has to give that non-residential customer 3 days notice for them to react and make their payments. And then if it's a residential customer, the supplier has to give that customer at least 5 days notice to react.
Okay, so you answered the first part of my question, whether it was intentional or not, and it is intentional. Is there a distinction, or a reason why we give residential customers 2 extra days, or a reason why we give commercial customers 2 less days?
The idea would be that non-residential customers are more sophisticated than residential customers. So that basically we would give our residential customers a little bit more time to act, assuming that they're less sophisticated than the business customers.
Okay. Thank you. I find your response to be sufficient. Okay. At this time, I will propose the motion. And
Your Honor, I'm truly sorry, but I have one housekeeping item that's been bothering me for about 15 years. It's on 20.53.02, which is a chapter that is reserved. But can we please change the spelling of competitive so that it is spelled correctly?
Well, what page are you on in 53, Mr. Green?
On page 8 of staff's filing, 20.53.02.
Yes, competitive is spelled wrong.
Second the motion, Mr. Chairman.
Thank you. This was opportunity to get that straightened out.
Mr. Green, I'm surprised it took you 15 years to bring that very substantive.
I'll try to do better next time.
All right. We will capture the typo there in the subtitles heading. And I now move to publish the proposed revised regulations in Title 20, subtitles 51, 53, 54, and 59, as filed by the Commission staff in this docket on Monday, March 8th, 2021, and revised here today in the Maryland Register for notice and comment, subject to non-substantive changes necessary to conform to COMAR drafting requirements. The vote begins with Commissioner Herman.
Thank you, Mr. Chairman. I'm going to vote no. I remain concerned with the slippery slope that I think we're starting down with the change in payment posting. Even though that only applies to few customers, it applies to the more vulnerable and payment challenged and leads to earlier disconnections. So that is my principal concern and causes me to vote no. I also have concerns with approving regulations that will cause utilities to incur costs without discussion or information on the allocation of those costs. The result is that utility customers are going to bear all of the utilities costs of implementation, even if those customers choose SOS. And I believe that SOS is a statutory choice in Maryland. And I'm concerned that those who are choosing not to participate in supplier consolidated billing are still going to bear the costs. So thank you very much.
Commissioner Herman votes no. Commissioner Linton.
Thank you, Mr. Chairman. I recognize that after 3 years and the many parties and many hours that have been put in towards this particular effort, that can't always get everything you want, and that's even true for me as a commissioner. I stated at the last hearing that I was philosophically opposed to the exclusion of customers either with an arrearage or who are low income, who've obtained assistance from the state to pay their utility bill. I think that as I know, and as a few people left who were around back then know, there was a lot of discussion then to make sure that low-income customers were able to participate in whatever benefits the deregulated market would offer. I know also, and we all know, that there have been many efforts over the years to prohibit low-income customers from participating in the deregulated markets, mostly by parties that may have some concerns about how the markets have been rolled out up until this point. So I don't think that it's appropriate to have some customers able to participate in whatever benefit comes from SCB, but at the same time have others that because they're 30 days late on a bill or have applied for assistance, especially during a pandemic, when we're encouraging customers to go get assistance, that we then say to them that you cannot participate in SCB. That being said, this is an initiative that was initially part of the original adoption of the deregulation in the state. It was one of the pillars of it, actually, from many years ago, and it's taken a long time to get to this point. Many parties have kind of begrudgingly come to the point of saying, it's okay, we'll go forward with it. And that's pretty much what's supposed to happen during a work group discussion. So for those reasons, I will vote aye.
Commissioner Linton votes aye. Commissioner O'Donnell.
Thank you, Mr. Chairman. Nothing is perfect in this world, to my knowledge. But I think we do have a statutory mandate, as Commissioner Linton says, notwithstanding the concerns that I may have with certain parts of these regulations and the process going forward. I'll give you an example. I have concerns with the priority payment protocols that we've adopted here that will prorate in a fashion that just gives me some concern and will maybe tend towards driving arrearages. There are other things that concern me. I think we've endeavored greatly to put in the appropriate consumer protections here. And lastly, I'll just say that as we implement this over the next few years, it's going to bear a high level of scrutiny by both our staff, the Office of People's Counsel, and the Commission itself. We saw earlier this morning in our AM what a level of scrutiny can do. And when we get to the licensing portion of this, when a supplier applies for a license renewal, this shouldn't be considered automatic. The due diligence the Commission has to do should not be considered automatic to approve SCB, but should come with a high degree of ferreting out whether or not these suppliers truly possess the capability of doing supplier consolidated billing. So having said all of that, and notwithstanding some of my concerns with some of this, I'm going to vote aye, Mr. Chairman, because I don't want to let the perfect be the enemy of the good. Thank you.
Commissioner O'Donnell votes aye. Commissioner Richard.
Mr. Chairman, I vote aye. I'm very pleased to do so. I think this advances the intent of the legislature, going back to 1999 in a Consumer Choice Act. And I do share some of the concerns about eligibility that Commissioner Linton did raise. And I hope that the phase 2 process will address those concerns adequately. And again, very pleased to vote aye.
Commissioner Richard votes aye. I'd like to associate myself with the comments of my 3 preceding colleagues. This was the law of the state back 21 years ago at this point, and I know that the parties have worked in good faith to get to where we are today. It was largely a consensus product, but at the same time, there were issues that were hotly contested. my colleagues just remarked that we shouldn't let the perfect be the enemy of the good, and I think that's where we are here. I think this allows sophisticated retail suppliers of electric and gas to proceed in the state with their own bills if they so choose. And I recognize that it'll take us a few years to get there if we have these sophisticated suppliers who are willing to undertake these complex requirements. It's not going to be an easy task. I particularly want to thank the utilities who have been working in the work group for the past few years, as well as our staff, notably Mr. Baker, Ms. Garofalo, and Ms. Knoll. With that, I vote aye. The motion is approved. With no other matters to address at this rulemaking hearing today, this rulemaking session is now finally adjourned. Thank you.
Thank you.